Easier now.
All right. Okay, so good afternoon. Thank you for joining us. Welcome to the session by the International Intellectual Property Committee. I'm really excited. We have a fabulous group of speakers today. My name is Professor Jan Osei-Tutu, and I'm the co-chair of the International Intellectual Property Committee, along with Sean Flynn from American University. And we're talking today about the Riyadh Design Law Treaty, as well as a little bit about the Treaty on Genetic Resources and Traditional Knowledge. And if you're attending and you're going to get the CLE credits, we will be giving out the CLE code at the end of the panel session. Okay, so there's CLE available for this session. So I'm just going to start by introducing our panelists. Our first speaker, each person will talk for about probably 10 or 11 minutes, and then we will leave time for questions at the end. So I'll just start with an introduction of our first speaker. We're really honored to have with us here today Anna Moravec-Mansfield, I probably did it wrong, who is the General Counsel at the World Intellectual Property Organization in Geneva, Switzerland, where she's responsible for providing expert and strategic legal advice to the WIPO. And Anna works on both intellectual property issues, but she also has expertise in international law, having previously worked with the State Department and as legal advisor to the United States Mission to the United Nations. So I'm going to just start with welcoming Anna to give us some introductory comments, and then we will move to our next speaker. Thank you.
Thank you, Jan, very much. And it's really lovely to be here with everyone. So I think I don't know how many are familiar with the World Intellectual Property Organization as an organization, WIPO. So I thought maybe to frame the panel, I would sort of zoom out a little bit and give you at least a little bit of a primer on who we are. We are an international organization based in Geneva of 194 member states. I love that number now because we have one more member state than the United Nations with our most recent accession by the Federated States of Micronesia. But we administer a number of different treaties, which I'll go through very, very rapidly. But these are our basic foundational dates. We, of course, are founded on two parent conventions, the Paris Convention for the Protection of Industrial Property, the patent side of the house, and then the Berne Convention for the protection of literary and artistic works, the copyright and related rights. And so we conduct, and we are a global international forum for international IP policy development, normative development, but we also administer IP rights. We administer a system through which international applicants can submit IP applications, and we work with a number of national IP offices around the world. We are, of course, also one of the specialized agencies of the United Nations. So our 28 treaties, so each of those two parent treaties that I mentioned, Berne and Paris, have spawned a number of specialized agreements. And so over the course of the 130 plus years of our existence, we now administer 28 different treaties, of course, two new treaties that were concluded in 2024, one of which we'll talk about today, or both of which perhaps if we're going to touch on the GRATK. But they can be broadly categorized into the three different areas of protection. So there are fundamental IP protection treaties. Then there, of course, are global registration systems. Again, the systems that I mentioned through which we charge fees for international filing applications like the Paris Convention, the PCT, the Madrid Agreement, Hague Agreement, and one on which is industrial designs, which we'll talk about the registration treaty that came out of that today. And so here you see a little timeline of all of our treaties, beginning, of course, in 1883 and 1886 with our parent conventions. And over the years, of course, each of those conventions has been refined. Some have had revisions and revision conferences. And you see that we've culminated with a wonderful year in 2024 with the conclusion of two new treaties. And so we are very privileged about that because while many commentators might say that the multilateral system and the international treaty system is struggling to find areas of convergence for international cooperation, we are still very, very pleased and happy that we have the level of international cooperation among our states that we do, and the result of which are 2 new treaties that have been decades in the making, of course. We'll talk a little bit about that. So they were not necessarily easy or quick roads to get there, but very successful nonetheless. And so just a little bit of how treaty making is conducted at WIPO. Of course, the normative work begins in our committees, our substantive committees. And the work on the treaty that we're talking about today began in our standing committee on the law of trademarks. But we, of course, have standing committees on copyright, standing committees on patent law. And so it runs the range of IP areas and IP protection. Once the committee concludes its work, it, of course, provides to the General Assembly a recommendation and what we call a basic document, and that document then would be approved by our 194 member states for moving on for the convocation of a diplomatic conference, which is the body at which a treaty is concluded. That diplomatic conference is supported by special sessions as may be necessary to further refine provisions of that basic agreement, and a preparatory committee that conducts some of the sort of rule-based issues around the diplomatic conference: who can participate, who can vote, where will the conference be, who will host it, et cetera, et cetera. And so the Riyadh Design Law Treaty was born in the Standing Committee on the Law of Trademarks. This standing committee, or the SCT as we know it, was responsible for a number of other treaties from our 28 administered treaties, notably the Singapore Treaty on the law of trademarks. But of course, we now have the Riyadh Design Law Treaty that we're very, very pleased to talk about today. With respect to the Riyadh Design Law Treaty, and it's named after the city in which it was concluded, we spent 2 weeks in the Kingdom of Saudi Arabia last November. And so they are also very proud to be hosts to a successful treaty conclusion. But it began, as you'll see, 20 years ago in 2005. So it was a very difficult road. And I know that in a previous discussion in this very room, one of the comments is often, technological changes happen much faster than regulators or treaty makers can actually legislate. And so at WIPO, what we are pleased about, though, and certainly it's a feature of the RDLT, is that we try to, where possible, blend legal predictability with flexibility. And so this treaty in particular has a sort of a double framework. It has obviously the treaty itself, treaty provisions, but then it is supported by a number of regulations which do not require a diplomatic conference for their amendment. So that allows updates to take place to keep the treaty timely and, of course, relevant. These are a number of the other dates. I will say what's notable about this discussion is this study on the potential impact that took place in 2012. So I believe, to my knowledge, certainly at WIPO, the RDLT is probably the only treaty for which the Secretariat sent out a questionnaire to sort of assess what is the level of harmonization, what is the level of work in individual member states on registrations for design protections. And then we actually did an impact study on what would a treaty do and how would it concretely, empirically benefit designers around the world. And so that really helped inform those discussions. And so we're quite pleased with that, because rather than an exclusively kind of member state driven, and this of course is always a member state driven process, always treaty making, but this was informed by some real good data that was done along the way. And so, as I mentioned, the Riyadh Design Law Treaty, named for the city at which it was adopted nearly 1 year ago by consensus. And so it has this double-tiered the structure, as I mentioned. It has the main articles of the treaty, but it's also supported by a number of rules and a resolution. And so it follows, in this respect, the similar structure for our 2 other treaties, Patent Law Treaty and the Singapore Treaty on the Law of Trademarks. And then part of the treaty making, of course, is when the treaty is successfully adopted on the last day, we have a major signing ceremony, which is a proud moment for the member states and the negotiators that were in those negotiations for 2 weeks. But the treaty, by its own terms, and many of our treaties are, is open for signature for 1 year. So in fact, this PowerPoint in the time that I traveled to New York is now out of date because we just had another signature in Geneva, because countries can have up until 1 year after the adoption of the treaty to sign it. And for those of you international law students, experts out there, of course, signature is your expression of eventual commitment to join. It's not legally binding in and of itself, but it is a very important politically, symbolically action to take. And so the treaty will enter into force 3 months after 15 eligible parties have ratified or acceded to it. And even that number was a number, believe it or not, that was heavily negotiated in Riyadh, because the number for entry into force is often, some of our treaties have 30, some have 5. And it's in some respects a reflection of member states for maybe how quickly or not they wish a treaty to enter into force. And so the overview of the Riyadh Design Law Treaty, it obviously looks for simplifying design formalities, basically trying to streamline a framework for designers to make it easier, faster, and cheaper for them to get protection. And so you don't have a number of differing, competing, cumbersome forms, for example. It tries to harmonize to the extent possible. And so we look at what are the benefits to the designers. And again, these are some of the issues that came up over the course of the years, but also in that impact study that I discussed. And the legal certainty, I think, was key, and the predictable requirements for design protection applications. And so they're clearly defined by the treaty. Oh, 2 minutes. Okay, sorry. And then this other information, which I know my panelists will talk about, this is where a number of issues like traditional cultural expressions, traditional knowledge, and to some extent genetic resources, because that would be included in that, including information on or other information. This is a significant and salient factor of the treaty. I will move quickly through some of the IP elements, which perhaps my fellow speakers can talk about the substantive IP elements of the treaty. But again, it's trying to make the process as easy and as simple for designers around the world. Increased efficiency and cost reduction, both for designers, but also for the IP offices, because they would hopefully see an increased filing activity and need to be much more efficient in how they address those additional filings. But design protection is really important, and it's an important element with respect to economic development, with respect to stimulating innovation. It's a way for designers to break into foreign markets. And through that impact study and all of the empirical analysis that was conducted, we see how important design is in the world. And certainly for designers from developing countries and least developed countries, we are looking at over 1.1 million design applications in 2022, which is a 50% increase over the last 10 years. So this is a significant part of the industry. Fashion industry, of course, relies on this. We looked at evaluating the fashion industry and how much design applications matter to the entire value chain. UNESCO has said the #1 ranked challenge that governments and decision makers must tackle if they want to realize the potential of Africa's fashion sector is the strengthening of legal protection for designers and professionals. That was a significant interest for many of our countries, even outside the continent. These are beautiful examples of designs, and some of our international designers who were supporters and advocates for the treaty. Just to give you an idea of how important this is around the world and how beautiful the creations are that will be protected. That is it. That is our design law treaty. Thank you very much. And I hope that was quick enough, but not rapid fire.
Thank you so much, Anna. And so our next speaker is Professor Christine Haidt-Farley, who I'm honored to have us join us here from American University College of Law. She's an expert on international intellectual property, serves as the faculty co-director for the program on information justice and intellectual property, and was involved with the Riyadh Design Law Treaty. So hopefully you can pick up where Anna left off. Thank you.
I don't. Good afternoon. I don't have any slides because every now and then I like to test and see whether I can actually speak without slides. So this is a test. All right. So I am going to try to frame what I want to say through the mechanism of kind of looking back. You just heard that the treaty was adopted a year ago, and then looking forward, because you also heard that countries are starting to sign the treaty, and so we're looking at the next steps. And I think it is anyone who works for WIPO's job to make a very rosy picture. And so as we think about countries, kind of weighing the question of whether to ratify this treaty, and if to ratify, thinking about how to implement the treaty, I'm going to provide kind of worst case scenario, things to think about, things to consider when thinking through those very important questions. So first, looking backward, I was slightly concerned that this treaty could be categorized as one of those international mechanisms that limits a country's sovereignty. I think many international mechanisms do that. And it does so here in limiting a country's sovereignty to develop their own design policy. And I'll explain how that is. So what I would like you to know is that in international design protection law, this area of intellectual property is much less harmonized than other areas of intellectual property law. So that in few countries, usually the most industrialized countries, design law is very, very well developed, whereas in most countries of the world, especially in least developed countries and developing countries, this area of law is not so very developed. And so looking back, I was concerned about two ways that this treaty was being portrayed. One was the suggestion, and it is more than a suggestion, as I'll get into, that this is a purely procedural treaty. The second is that this treaty is good for small and medium enterprises, medium-sized enterprises, good for individual designers. So I want to take each of those in turn. So first, procedural. This treaty is in a small minority of treaties that Anna told you about that is directed at the application process for the registration of an intellectual property. So this treaty outlines what an office can demand of an applicant and thereby suggests things that it can't demand and to be a member of this treaty. The objective there, as was said, is to regularize and streamline the application process. To do so definitely reduces transaction costs and definitely increases predictability, which are both very worthy goals. So I say this treaty is framed as purely procedural, and that is definitely so in its portrayal, but it's also in its text. In its text, there is a provision that says this is a procedural treaty. Nothing should be interpreted as being substantive. That is a curious thing when I've already told you that this is not an area of law that is already harmonized at the substantive level. So it's curious to put procedure before substance. And I think there can be kind of acute consequences in terms of removing that policy space for countries to develop their own systems of protecting design and then thinking about harmonizing procedure. When you think about it in our substantive intellectual property treaties, the treaty set out substantive minimum protections, right? To be a member of this treaty, you must protect at this minimum level patents in this way, trademarks in this way, copyrights in this way. And what that means is that countries are free to determine how to do that to a large extent and to what level to do that, so long as they meet the minimum. This treaty kind of comes at the obligations in the reverse way by explicitly removing discretion, right? If you're a member of this treaty, you may not do this application process differently than is prescribed in this treaty. Okay, so in that case, it is very important to understand the substantive implications of these procedural changes. Now I want to talk about the second portrayal of the treaty, which is that it's good for small and medium-sized enterprises and individual designers. I would say looking forward, it might be good for small and medium-sized enterprises and individual designers, but it's certainly no better for these groups than for any other groups, and it could be potentially worse. So the rules in the treaty create advantages that sophisticated actors with global portfolios of designs can easily take advantage of. These kind of entities typically have a large number of designs that they want to protect. They typically have a large number of registrations in certain countries. And the real benefit of this treaty is it allows those people to take those applications and extend them to other countries without having to calculate what kind of transaction costs will be involved and what kind of uncertainties there will be. So it easily allows them to extend that portfolio. Small and medium-sized enterprises don't usually have that objective. They're not interested in expanding their portfolio. They're interested in using their very limited legal budgets to figure out where exactly they need protection. Typically, that's at home and only at home. So extending a portfolio is really not their concern. For these small and medium-sized industries, really what would be most beneficial would be an uncluttered registry at home, right? So a clear path for them to receive a registration where it is they're doing business. And when we say that this treaty will make it easier and cheaper for people to file for registrations, we anticipate there will be more registrations, and there will be more registrations in countries that are not already in the high priority areas for registering, right? So it will mean that those registries in developing countries will become more cluttered. And it is important to know that in most countries of the world, when a design is registered, unlike a patent, the office will not do a substantive examination of the application. That means it's not really reviewing to see whether the application meets its standards. A design may be registered that doesn't comply with local law, but then it is the obligation of another party to challenge it. And that's something that takes resources that small and medium-sized enterprises usually don't have. So to the question of should developing countries ratify the Design Law Treaty, I wouldn't argue that they shouldn't, but I think they should go into it wide-eyed. Again, the framing still exists that this is good for small and medium-sized enterprises. I think there will be pressure for countries to ratify. I think this is in the interest of developing countries who will pressure developed countries who will pressure developing countries to ratify. I think countries often think that intellectual property treaties are good to ratify because it signals that they are investment friendly. And I very recently had the registrar from an office in a small country in one of my classes who explained to me how happy her office always was to receive registration fees. So I think this is already attractive. So the real question then is how to implement the treaty. Again, there is a danger that the treaty is being portrayed as purely procedural, only technical. And so it may seem quite simple then to implement. And I think there are some traps in not seeing the substantive implications. There are flexibilities built into the treaty. Those were hard-fought flexibilities built into the treaty, but they're not immediately visible. They take some work to understand. So I suggest some caution in implementing and just really using the available space to figure out how to implement the treaty in a manner which is consistent with the way the country thinks they might develop their design protection law. In closing, I'll just say design is an area of intellectual property law that I think is underdeveloped in international law especially, because the policy justifications around protecting design, the way an industrial object looks, is far less clear than the policy for protecting inventions and for protecting creative works. And I also think that the dangers of overlapping rights, that is, using design protection to supplement copyright protection, trademark protection, patent protection, or instead of, or really eschewing registered designs, which have quite short durations in lieu of finding design protection elsewhere, is really something real that policymakers pay attention to. So for these reasons, I think procedure preceding substance means that we have a space in which we really have a reason to want to have policy debates around the way design should be protected, and we've kind of leapfrogged over it in a way that I think might close off some of that debate. Sorry to be so negative. Thank you.
So I'm next going to invite Professor Margot Bagley to the stage to speak with us. And Professor Margot Bagley is the Asa Griggs Chandler Professor of Law at Emory University and has been involved with some of the negotiations at WIPO. So we're very grateful to have her here.
Thanks. Now, how do I pull up my slides?
Oh, her slide.
But they're on the desktop. I did not know.
You never do slides, Peter?
Escape, there we go. Perfect. Is this one yours? No. It's Bagley. Yeah. I see. Very okay. Go to here. Perfect. And then you should put it. Great. Thank you so much. And thank you, Jan, for putting together this wonderful panel. I'm going to, and you're going to hear some overlap between some of the things that Christine talked about and what I will be talking about. Hopefully they will be complementary. I'm going to focus just on one aspect of the substantive issues that Christine mentioned, and and Anna mentioned as well, that relates to the ability of countries to require applicants to disclose the origin of traditional knowledge, TK, traditional cultural expressions, TCEs, or genetic resources, GRs, that are used in creating an industrial design. And I have to note, I spoke on this topic Monday night in Lisbon, but I had 45 minutes. And now I have 10. And so I've cut a lot. And there may be some gaps, and hopefully we could explore those in Q&A. All right. So as was mentioned, a key feature of the draft design law treaty when it was first put together and negotiated was this highly touted closed list of items an office could require an applicant to disclose. And the idea was that if national offices harmonized on this and other points, that would facilitate multi-country filing and protection for designers. But in 2024, the African group of countries took a closer look with a little help from some folks and realized that agreeing to the DLT with its closed list could be very problematic, not only in relation to policy coherence with its work in another WIPO committee, but also policy space for determining what kind of design regime made sense for countries, especially if they did not have design-intensive industries yet or meaningfully intensive industries yet. And there was a particular concern in relation to not being able to require disclosure of TK, TCEs used in creating designs because of misappropriation concerns and the fact that, as Christine noted, many design regimes are just registration regimes, no substantive examination. So it's possible that rights could issue that should not have been granted and then have to be challenged by third parties. I've often felt, and especially when it comes to the DLT, that a picture's worth 1,000 words. So here are a few, I've cut them down, pictures of items that are protected or could be protected, could be eligible for industrial design protection, and that raise cultural misappropriation and other issues. So I'm going to just zoom kind of through these. We've got Australian indigenous animal drawings on chocolate. We've got Valentino bag with chocolate mask, design right on Ghanaian Adinkra, alphabet, Louis Vuitton shirt with Basotho blanket designs, and Jan, you should remember this, Vera Bradley bags with Ghanaian Adinkra symbols on them. Here's an example mango sweater using work from an indigenous group in Mexico, similar to a Romanian vest and Romanian coat, Tory Birch. This one, I presented this in New Zealand some years ago, and folks from the Ministry of Business Innovation and Employment came up to me after my talk. They're like, we have an example for you. And they're like, and they told me about these shower curtains that had these Maori designs, these important designs on them that were profoundly hurtful and offensive to the Maori people. I mean, but why would you want this on your shower curtain? I don't know. Nevertheless, there are so many designs, and it was really quite challenging. Christian Louboutin Paloma bag with Kente on it. And it's quite challenging to search for pictures using words. And so there I am with Ruth Akedeji of Harvard Law School, Chichi Mesa. This was back in 2014 when we were defending the African group position and coming up with really information to make clear the concerns that the African group was having. Now, because of these concerns, the African group inserted into that closed list this BODE provision that would allow, not require, but allow countries to require applicants to disclose the origin or source of TCEs, TK, or biological or genetic resources utilized and are created, creating or incorporated in the design. And there were very good reasons for wanting this provision, but it caused a bit of an uproar in the SCT, and it had the effect of shutting down negotiations in the SCT for 7 years, literally. Demander countries would only discuss it once a year during the General Assemblies. Now, even countries that were convinced by the pictures, and there were many that were, they would come and talk to me like, on the sidelines. Okay, like this is real. We get this. The African group isn't just making this up. They were resistant to the idea of disclosure of origin for genetic resources. It's like, designs only protect appearance, so you can make it out of something else, right? However, many countries may choose not to extend protection to the design of an article made using illegally acquired genetic resources in the same way they might choose not to extend patent protection to a drug made using illegally acquired genetic resources. And with the rise in biodesign and synthetic biology, new uses of genetic resources in design creation are appearing all of the time. And a few more pictures might help illustrate here as well. We've got a 3D printed seat made from mycelium, a lamp made from mushroom material. I love this one. This is black textile waste and mushroom mycelium, which formed a white fungal network across the material. So it's not a person designing it. It is the genetic resources themselves that are creating the design. Similarly here, a swarm of 6,500 silkworms are placed on the structure, and the silk, as they spin it, affects the density and the appearance of this article of manufacture. Bees actively building upon a form and depositing wax and giving it this particular appearance. We've got a kimono made from kombucha, shrimp-derived bioplastic articles, genetically modified silkworms creating fluorescent silk, scarves dyed in bacterial secretion. So again, it's the bacteria secreting stuff that's creating the design that is used on the scarf. So genetic resources absolutely matter in design. And there's also a much closer link between utility patent protection and design protection than many people realize. Many products are protected by both utility patents and design rights. So here's a double lumen catheter protected by a design right, and the same catheter protected by utility patent. During the smartphone wars, Apple got a $1 billion award against Samsung. It was reduced on appeal, but largely based on design protection, not just utility patent protection, those rounded corners of your iPhone. And many pills, drugs, are protected by design rights, in addition, of course, to being protected by utility patents. So many of the same reasons why countries would want disclosure of genetic resource origin for utility patents, which they were seeking in the WIPO GRATK treaty, they also would want for design rights. So the DIPCON came, the treaty was adopted, but as has been noted, not with the ease that many expected. The negotiations were contentious. The treaty ended up having not only reservations on certain provisions, but a resolution about the meaning of some provisions. The words TK and TCE were explicitly concluded, but the words genetic resources were not. And Anna, I greatly appreciate you saying that it's included, because that's what I explicitly said at 4:28 in the morning on the last day during my closing statement on behalf of the Africa group. But something has happened since the DIPCON that I find to be both fascinating and troubling. When you read descriptions, mostly from WIPO, not Anna, but mostly from WIPO. So if you go to Wikipedia and it says it's coming from WIPO, it sounds like this treaty is harmonized, you know, that all countries have to provide this grace period and they've got to do this, that, and the other. And it set a maximum list of indications or elements that designers must submit. On the WIPO website, the executive summary, providing a predictable framework, you know, maximum list of the indications and elements that may be required, but it can have TCEs and TK. And then an article that came out recently doubling down on this. Article 4 deals with the maximum requirements for registration of industrial designs. It contains an exhaustive list of all elements that may be required. The decisive factor here is that it clearly states that no further requirements may be required. And even a commentator from a development-oriented intergovernmental organization said it sets the maximum list of indications or elements. And I'm like, interesting. So these statements give the impression that the DLT truly provides a closed list of items a country can require, and that it has some other harmonized things as well. Okay, all right. But that impression is incorrect. So here's what it actually says, that a contracting party can require an application contains some or all of the following. It does say that a contracting party can require other information, including information on TCEs and TK, that is relevant to the eligibility for registration of the industrial design. Article 2, and this is something Christine noted, Nothing in this treaty is dealing with substance. Countries can still prescribe such requirements of the applicable substantive laws it desires. And in fact, the Design Law Treaty does not define an industrial design. That's left to national law. So countries, if they can decide what can be an industrial design, they can set the requirements for eligibility of an industrial design, which means they can include genetic resources or say that you have to disclose if you used artificial intelligence in creating your design. Whatever the country decides is relevant to eligibility gets included. And these are things that can, and we would expect them to vary by country. So this is not a closed list. It is not exhaustive. It is not a maximum indication of what a country, it is not providing harmony. Now, this view can become a self-fulfilling prophecy because of Article 24, technical assistance, which WIPO does quite a bit of. And this was actually a highly thought over provision. But even here, even though it says development-oriented, demand-driven, it says taking into account the priorities and the specific needs of receiving countries for enabling the users to take full advantage of the provisions of the treaty. It's about benefiting users. It's not about benefiting those countries or the designers in those countries if they don't have design-intensive industries. And using WIPO statistics, the commentator points out that 75% of global design activity comes from China, Korea, the US, European Union, and Japan, less than 3% from Africa, the Caribbean, Latin America, and Oceania combined. Okay, so we would not expect there to be, okay, all right, we are not expecting there to be lots of designs, at least in the near term, coming from designers in low and middle income countries. All right, so I'm going to stop here. It looks inclusive, it looks harmonized. These are illusory. Thanks so much.
Okay, I'm just going to introduce our next two speakers really quickly. We're going to have Professor Sean Flynn, who's the co-chair of the International IP Committee, who's a professor at American University and the Geneva Graduate Institute. And then Peter Yu will follow up and wrap up for us. And he's a professor of law at Texas A&M, expert in international IP, and vice president at Avila. I'm the vice president. So you probably need her help, right?
Maybe,
To do
I
this.
forget how to.
And I know the pack started a little bit late, so hopefully I don't know if we'll be able to go over by 5 minutes.
I think you got a little.
It's down maybe.
No, I just need to minimize it. I just cannot see.
This one.
Yep.
Great, thank you. So that last presentation, that was actually, there was a huge change in Article 3 because, I mean, part of the framing reflects this. It started at a very closed list, and that final language really appeared in the end of the negotiation to make it a much more open list. And so it was a real product of some of the advocacy going on in the room, including what Margot was doing. Margot and Christina and I went to the Riyadh Design Law Treaty, and I think it was us three and maybe 3 other people in the room, maybe only one other person in the room, kind of representing kind of public interest, academic perspectives. And there are only a few people representing business perspectives as well. I mean, there just weren't a lot of outsiders who weren't negotiating the treaty. And one of the things you find in this kind of treaty that doesn't have a lot of attention drawn to it is issues pop up and there's not enough expertise in the room to focus on it. So I wanted to pick up on one of those issues, which is the EU voting requirements. And it's kind of an interesting issue because it's now expanding to other fields. So this one is not really just a IP issue. So the question is, how many votes do EU countries have in the DLT assembly? It could be 0, it could be 1, it could be 28, it could be 29. These are all interpretations that are kind of floating around. And so let me kind of unpack that story a little bit. So this is predominantly about the EU, or what used to be called the European Communities. So post-World War II, the European Communities start in 1951 or 1957 or 1967. There's kind of a growth of European integration, starting in trade and environment. And so you see in the UN system, a number of early trade and environmental treaties allow for the possibilities of membership in the treaty itself by an intergovernmental organization. So this is an exception. Most treaties, the members are member states, not intergovernmental organizations. And so the question becomes, when the member is an intergovernmental organization, how many votes does it have? And so a lot of these early treaties have language like this. So this one is specifically about the European Economic Community. This is the first or second example of what became kind of the mainstream language. It says the EEC or other regional economic integration organizations shall exercise the right to vote with a number of votes equal to the number of member states which are contracting parties. So the idea is the IGO can join and become a member, a contracting party, but the members themselves have to join as well. So if only 5 of the EU countries join, then the EU or the EC or whatever it is will only have 5 votes, etc. If they all join, then it can have all of those votes. And there's also this little language at the bottom that, if any member pulls out and decides to vote individually, then the intergovernmental organization no longer has a vote. So it allows them only to vote on behalf of basically the consensus that may already exist in that intergovernmental organization. Okay, so this is the Maastricht Treaty. So now we're moving to 1993. The EU becomes the EU, and it provides that the EU shall have exclusive competence for the conclusion of international agreements when its conclusion is provided and that it is necessary to enable the union to exercise its internal competence, its exclusive competence. And then there's the list of the issues reflecting the earlier days, customs union, trade, etc. But then E, common commercial policy, is included. And this becomes a potentially very broad term that's a little contested and unclear for a long time. So intellectual property could be common policy. Each EU country has its own intellectual property laws, and they can vary, but at the same time, the EU sets directives that are kind of like treaties that all the different members have to follow. So to that extent, they can have common terms. So including before all those UN agreements, IP treaties don't apply to international organizations. So the Berne Convention, this language appears in most of those, that each country member shall have a vote, right? It doesn't say anything about IGOs. The issue of international organizations having voting arises first in 1989 in a treaty that is not actually enforced. The EU was really created in 1993, and the issue becomes more recurrent and really the norm after 1996, the so-called internet treaties, and all of the more modern IP treaties have a clause that looks something like, this is the Washington Treaty, which I want to show you just because it has a unique phrase that was added, that it can only exercise the votes for the members that are there, that are present, which is an important kind of protection. So they can't just send one person into the room and vote 28 times. They can only vote based on both the parties and who are actually present in the room. Okay, but that actually is not the standard. The standard looks something more like this. It looks like that first example. So this is the WCT, WIPO Copyright Treaty. Each contracting party shall have a vote, and the IGOs can vote with a number of votes equal to the number of its member states which are party to the treaty, okay? So that is reflected, that same language is reflected in most of the modern treaties, but in 2017, after the Marrakesh Treaty, which was in 2013, the European Court of Justice decides that IP is an area of exclusive competence in the EU. Meaning, at least this is the present interpretation with the EU, that the countries cannot join as individual parties. Only the EU can join as a party. So now, if you have the number of votes equivalent to the member states that are a party, but none of them are parties because they can't join, then how many votes do you have? Do you have 0? Do you have 1? So when the EU enters the DLT, with this decision coming behind them, they declare that this is an area of exclusive competence. So even though intellectual property looks to me like something that's concurrent, there's overlapping areas of EU can legislate in this area, but each country has some autonomy. They now declare, based on this ruling, this is an area of exclusive competence, meaning only the EU can negotiate this treaty. They order that the EU and its negotiating achieve votes based on all of its members. They propose during the legislation to change that standard language and say, well, given this new problem that we have and this new interpretation, we want to change the language that says you'll have a vote equal to the number of members that are party to the treaty to the number of members that are bound by the treaty. It's important constitutional because this means that the EU can come and negotiate a treaty and bind all of its members, even if those members don't want to be bound by the treaty. So in the old world, France or whoever could decide, well, I don't want to be bound by this treaty. The EU can get the votes for everybody except for France, but France could not be bound. But now through the new interpretation, the EU can bind all of its members and have votes for all of its members, even the ones that don't want to be bound by the treaty. And in addition, for instance, in a quorum, it would have that many. This does not pass. So the final DLT has language that looks much more like the old model. And it's based on this language that we have to answer the question, how many votes does the EU have? So each contracting party shall be represented in the assembly by one delegate. So the EU can be a contracting party, so the EU can negotiate the treaty, join as a contracting party. Contracting party that is an intergovernmental organization may participate in the vote in place of its member states with a number of votes equal to the number of its member states which are party to the treaty, not which are bound by the treaty. So how many votes does the EU get? This issue is popping up in other areas. The last panel was on the pandemic treaty. And this is the first area kind of outside trade and IP where I've seen the same issue pop up. So health, like IP, you could say is an area of kind of concurrent jurisdiction, but the EU again is saying, well, now it's exclusive. We're going to say this is exclusive too. They don't have the same ECJ ruling, but they're starting to argue, we want to negotiate this on behalf of the EU, bind all of our members and have votes for all of our members. But the same language occurs here, which is they have votes based on members that are parties. So if the other members don't join, how many votes does it have? I don't know the answer to that question. I met somebody, there's a woman here named Josephine that I met yesterday that works on this issue. She says the answer is 28, that despite the language not being changed and adopted, they should still have 28 votes. But then you have to get past this language. Well, how do you have 28 if you have one contracting party? Why do you have 28 votes? Should you have 28 votes? What's the kind of implication for balance of power and negotiations, et cetera, if one entity can say, I'm negotiating on behalf of 28 parties and I'm going to have 28 votes? In the quorum, the quorum has to be half of the contracting parties. How many did you say have to sign the treaty for it to go into force? 15? So could it go into force with just the EU? Do they get 28 members going into force? Okay, these are some of the questions drawn by this example.
Okay, I'll speak from here so I can move the neck a little bit. So the beauty of being the last on the panel is that you just look at what you have, cross it out, cross it out, cross it out. And then you're like, what else do I have to say for this panel? So what I'm going to do is to actually tie together some of the discussions here in the international IP context, so that it'll be easier for people to ask questions, to think about what's going on. And let's start with some of the students here. So you hear some of our speakers talking about, well, this is basically a procedural treaty, but looks like very much of a substantive treaty, right? And so what's interesting for those of us who have been teaching international IP is that there are certain treaties we get excited about, and there are certain treaties we just don't, right? And treaties that are not the most uninteresting are those what we call housekeeping treaties. They are basically classification treaties, talking about what type of classes of goods, what type of, how do you classify about the technological materials. Those are things that will not be covered. And procedural treaties is actually very hard to cover because we just could not get students interested in a topic, right? And for a long while, I've a tough time actually understand why it's exciting to talk about design law treaty until I actually listened to Christine's presentation in Copenhagen. And she was explaining what's going on. She's talking about how that will affect, for example, the power of the government, the sovereignty issues. But then I think about it is like she's treating this as if this is a substantive treaty. Of course, there will be a lot of things to talk about, right? And from what I remember, talking to some of the people in Geneva, some of the NGO officials always say that whenever you get a procedural agreement, that's the most dangerous. It's kind of like a very smooth cocktail, but with a lot of alcohol. Right? So you keep on drinking and not thinking about it, and then you feel it, right? Where substantive agreement is basically something that's very strong. You drink it, you already know that what you're getting into, right? So I think that would give you some ideas to why it will be actually interesting to have this debate about a substantive versus procedural agreement. The other thing which has not been mentioned by the panelists here is that we need to put together the context surrounding the agreements, right? So there's always an interesting debate as to whether we will actually get the two diplomatic conferences from WIPO, one about the DLT, the other is about the genetic resources and associated TK treaty without the war between Russia and Ukraine. Right, so if you actually go back to the TRIPS Council minutes, there's been some discussion going back and forth about what we need to do in light of the war, and other people say, why don't we just also talk about it, the Treaty on Traditional Knowledge, since it has been going on in the Intergovernmental Committee for more than 2 decades, right? So I think this is actually very interesting, and when you actually go back to think about the Doha Declaration, we also think about 9/11. Or the TRIPS agreement, we're thinking about the fall of Berlin Wall, right? So this year is the time where I have to do a lot of revisiting because the TRIPS agreement is celebrating the 30th anniversary. When you go back to read a lot of those discussions, you cannot feel that they are basically thinking about the fall of the Berlin Wall. Why? Because the negotiation session, especially the Brussels meeting, is in 1990, right? Think what happened in 1989, right? So I think it's very important whenever we talk about international IP, we need to keep in mind the context, especially with respect to geopolitics. So when I teach a class on the Joe Berger case about McDonald's in trademark and about South Africa, one thing that I always ask students is, well, think about what happened in that case. And that case is just about the Paris Convention, about trademark law, but they did not mention apartheid, right? But without understanding apartheid and all these companies are going back into South Africa to trade again, it's much harder to understand the decision. So that part about international norm setting. The second thing I want to get to is about WIPO, right? So I think it's actually very surprising for a lot of people to realize that there have only been 7 agreements coming out of WIPO since the adoption of the TRIPS agreement. I always joke about the fact that if you have been teaching international IP long enough, after you wait for about 2 decades, you see a treaty, right? So I started writing about traditional knowledge and putting together conferences, and one of those where Professor Ragavan, who is laughing over there, was actually a speaker at Cardoso. It's this early day that's in 2001. And then we have to wait for basically more than 20 years. Then we finally get an agreement, right? And so I think what you see is actually quite interesting because we got the two WIPO internet treaties was mentioned early on, the WCT and also WPPT. And then we got a decade of no action. And then we got basically three agreements. One is the Marrakesh Treaty for the visually impaired. We have the Beijing Treaty on audiovisual rights. And then we also get the Lisbon Agreement with respect to geographic indications. And then we get a decade of no action. And now we basically get both the traditional genetic resources treaty as well as design law treaty. So a lot of people are thinking about, well, at WIPO, there's still the treaty about, for example, broadcasting organizations. There are treaties about the traditional cultural expressions and traditional knowledge, whether it's combined into one instrument or whether it's in two. But if we actually look at the track record, those treaties are not coming anytime soon. If we see that a time gap from 2 or 3 treaties before we have another 2 or 3 treaties. Partly is because it's just a lot of the countries do not have the negotiating ability to deal with a lot of those issues. Part of it is there's internal dynamics within international organizations. Sometimes it's because of elections, sometimes because of other things. So that makes it much more complicated. And so it's always an interesting question when we ask, well, are we going to see more treaties coming from WIPO? Are we going to see the TK and TCE treaties being completed? Then I think the track record actually is not that optimistic in that direction. The other thing that I think will be quite interesting, but obviously I'm probably more cynical, and I have Anna sitting next to me right there, is that there's always parallel developments within WIPO, right? You want to go for the design law treaty that's favored by a lot of different countries, especially EU. Then you have the TK treaty that's favored by different countries. If you want to have the WIPO development agenda, then there's a push for actor enforcement, the advisory committee on enforcement, right? Or you can think about even going to, for example, Marrakesh, and then you have Beijing Treaty and Lisbon on the other hand, right? So there's always a parallel development because WIPO is a very complex organization, right? So there were times when people were so excited about, for example, development agenda, they're thinking about the fact that, well, we are going to look at everything through the development dimension. And my immediate thought is like, that's not going to work that way. Right, you can go on this side to do the development agenda, do development dimension. There are other activities about the PCT, about the other treaties. They're going on at the same time, right? So I think we just need to be conscious of that. The third thing I want to share with you is actually about the interrelationship between WIPO and WTO, and that was actually from the earlier panel, right? And where you guys have about the global health, right? So I think the design law treaty is a very good example to show that the position of WIPO or what WIPO offers cannot be easily replaced by another organization. I just cannot see the WTO doing it. There are provisions with respect to industrial designs within TRIPS agreement, but trying to put together a design law treaty is just outside the traditional expertise and competence from the organization standpoint, right? So I think there's a very interesting debate as to whether we can actually try to focus on a lot of the IP norm setting in certain organizations as opposed to having multiple organizations. But I think this is a very good example to show that, well, WIPO has a very unique place to play with respect to these type of treaties. And I think it can actually contrast what's going on with the Treaty on Genetic Resources and Associated Traditional Knowledge. Because when you look at that treaty, we have the treaty adopted at WIPO. But more than 10 years ago, there was more or less the same proposal at the WTO, which is Article 29 bis. And yet, Article 29 bis did not get adopted with respect to WTO. And so that's an interesting question as to whether WIPO actually is a better forum or whether people just don't want to deal with the WTO because there's a mandatory dispute settlement process. Right, so I think from an international organization's standpoint, that's quite interesting. And the last thing I'll end on is basically about coming back to here in the US, right? So a lot of the things, I think yesterday we talked about, I think actually Leila Sadas talked about Eleanor Roosevelt talking about how to set up all these human rights treaties and what type of issues. And then the answer is, well, we start small things in our neighborhood, right? And so I think it's good to actually bring back to US here. Both treaties are adopted before the current administration, so it's very hard to actually tell how they'll play out. But with respect to the emphasis in multilateralism, I think that will be quite interesting in terms of how we expect international agreements. So when you think about, for example, the import tariffs that have been going on, the negotiation seems how should I put it? Signing on the dotted line seems to be just the beginning of a relationship, right? It's not the end point of the discussion. If that is the case, then our conception of what an agreement will do at the international level is very different from what we expect, right? So I think that point will be important. I think another point will be important is, are we moving further away from multilateralism to more regionalism? If we have more regionalism, who will be the players? And I think that would be quite interesting, right? So one thing I immediately think of about the Design Law Treaty is that, well, this a treaty will probably affect China quite a bit, because China has the largest volume of industrial designs applications every year, right? I think it's about 800,000 applications a year, right? So that basically goes to the point I think Michael made early on about only a small percentage that coming from other countries. But when you look at the data from China, you also find that more than 98% of the applicants are domestic, right? So to the extent we're trying to actually harmonize the standards, to have some type of procedures, and most of the applicants are basically resident applicants, then you probably don't need to go have a treaty in order to actually address a lot of those issues. You need more international norm setting when you actually have a lot of non-resident applicants. And another thing we can also, okay, I was not looking at you intentionally. Yeah, so the last thing I'll end on, because you cannot have any international IP discussion without talking about AI. So I'm not going to start here talk about AI, but I want you guys to actually think about what are the different choices that will be available for future international norm making. That will be true for design law treaty. That will be true for traditional knowledge. That will also be true for AI. Do we use hard law treaty? Do we use soft law recommendations? Do we go for a multi-stakeholder dialogue? Do we go for choice of law, technological intervention, or private ordering, right? All of them will be good choices. But then the question is, right, which one will actually fit better with the different topics? So I'll stop here, pass it back to Jen.
Thank you so much, Peter. Thank you to all our speakers. I'm told we have to get out of this room by 4:20ish, even though we started late. But if you're here for CLE, the code is London, London, like the city London. And if does anyone have any questions? I know there's, okay. So Shri, I'm going to take you second since you're ready. Sir, if you'd like to ask your question, then Shri can ask and we can quickly. Any other questions in the room? Oh, you as well.
Oh, we can take all.
Let's take all of the questions. So we'll start with you, sir, first, and then we only have a couple minutes. Thank you.
And I love your presentation. I'm interested in the informal market in Jamaica, where you have a lot of artisans on the side, and the tourist ships come in, and they're selling these wonderful artifacts. What protection does this treaty, Design Law Treaty, help to these informal, the formal? What has to be done to protect these artists that may not be like federal? Or is there any protection whatsoever?
Okay, thank you. And then we'll take the next question, ma'am. And then Shri. Go ahead.
In my LLB right now, master's in IP law at NYU. And just to premise by saying I haven't particularly studied design law, but a lot of the things you said kind of, and especially about the harmonization of design protection across the world, it kind of triggers some thoughts in me about like the concerns people have when like, for example, on the harmonization of trademarks is brought up, because the more you harmonize, I guess, IP protection across the world, the more congested it is. And then I guess back to your point of like protecting designs where they're actually sold or where they're actually marketed. I'm not sure about the extent of design protection, but is like a treaty and like global harmonization the best way, I guess, to go about like design protection running maybe might give rise to that risk of like kind of halting future developments and so on.
Okay, thank you. And then Professor Raghavan, I put you last because I know you can speak to everyone, so then we'll just take.
Yeah, both of those questions were very informative. On the first one, right, I think about India. India just had a huge dispute with Prada and the Kolhapuri shoes, right? I don't know how many of you are aware. And then taking off from your question, every sari in India is a different design. Every one of them virtually. I didn't know how the design treaty would, deal with that. And I teach patent law, so from that vantage, I just wanted to say something, right? The value of each US patent, I believe, started going down when the Federal Circuit seriously thought that its job was to always side with the inventor, no matter how minimal the innovation was in that patent, right? And I see that now happening with WIPO, right? We are at a stage where we want to protect everything. And that segues into what, your question was, because when we end up protecting everything, then the value of each item that we protect actually goes down, not up, right? Because then, it really stifles creativity more than helps creativity. So that's something.
Thank you.
For us to think about when we have treaties like the design law treaty.
Thank you. I'll just invite our panelists if you can respond in 30 seconds or less, because they're about to kick us out of the room. So I don't know who wants to take it away.
For that protection, but some of the kinds of things you're talking about, obviously to be protected about copyright, which was your original work of law, which was fixed on tangible media.
I guess I'll just a little bit, which is that, and it relates to what Margot said about you need to register design rights. That intellectual property is territorial. So if you have rights where you've registered the rights. And so if somebody gets on the ship with that art and they then, take it to a manufacturing to make more, then you have no rights against those things. So I think for the very small designer, if they could get registrations everywhere, then they could block all of the things that Margot showed you in the slides, but that's what it would take, and that's never going to happen. So really the best use of intellectual property for them might be not to have any intellectual property so that they can still make those things, and no outsider is going to say, well, we have a registration for just the corner of the thing that you've got in your design, and therefore you can't make that design anymore.
So I'd like to invite you to join me in thanking the panel. I wish we had more time, but you can always grab them and speak to them afterwards. So thank you so much for attending, and thank you to our panelists.
Great. Will you take our picture?
Yes.
Does somebody have a better camera than mine? Mine's kind of stinky. Yours is good? Okay. Yes, no, I need you to picture.
Please come in.
Sure.
You want to be sit?
Yeah.
Okay. Yeah. Yeah.